Hello and Namaste. I'm Sayantani Ray, a fourth-year law student interning at ubAdvocate under the guidance of Mr. Jeevan Prakash Sir, AOR Supreme Court. Today, I'll be discussing the lacunas of Section 45 of Indian Evidence Act 1872. In simple terms, if we examine the phrase expert opinion and try to decipher it, it indicates an opinion offered by a person who is expert in certain subjects such as science, art, law, or any other technical professions. This idea is also contemplated by Section 45 of the Indian Evidence Act of 1872. A cursory perusal of the part reveals that the plan of this section has placed an emphasis on various categories of specialists such as international law, science, art, fingerprints, handwriting, and so on. However, the clause lacks a comprehensive approach because these other disciplines of science were not recognized at the time the Act was drafted in 1872. So the crucial aspect in these definitions are two phases: expert and opinion. A person who has obtained any unique expertise or training in a particular field to which the court inquiry requires or relate to, that person may be regarded as an expert. Whereas an opinion is a brief or assessment what one believes about a particular matter or topic, an assessment short of ground of proof, a formal explanation for reasoning on the basis of expert advice. These are opinions. After examining the situation, the expert provides his or her opinion, which is an advised opinion, not a binding one. An expert's conclusion is to be offered as an opinion, not as a factual conclusion. It is a corroborative to the case's facts and circumstances. So, if an unimpeachable eyewitness or documentary evidence opposes an opinion, it will not have any advantage over the direct proof. Expert opinion is just an assistant to the judge in forming an impartial view in all matters. There are four tests that an expert opinion should be followed. First test is based on the education background of the expert. This implies that even the doctor is examined, scrutinized, and cross-examined. As held in Dhovi Yadav versus State of Bihar, if his opinion and observation in his statements are validated, the report may be examined. Otherwise, it cannot be. As a result, even doctor examination is required. The second test involves exhibits and graphics that experts present or create. He should not base his decision on recollection and scribble notes, but he should have such high degree of opinion that he defend his position even if the other party counter questions. The third test is whether or not he is prepared to disclosure his tactics and processes. As an expert, he should not be sloppy in presenting the method he has followed. And he should be so certain that no one can accuse him for skipping process in obtaining the finding. And the ultimate litmus test is that an expert is conservative and cautious and expresses his view that one of the offenses was most likely perpetrated solely by the accused standing there. It is well-established notion that the opinion of an expert should be treated with extreme caution and decision should not be made only on the basis of the opinion expert without sufficient confirmation, since it's very dangerous. As ruled in Magan Bihar Lal versus State of Punjab, the definition of expert opinion is weak and infirm, and such cannot constitute a foundation of conviction. It is an obligation of court not to take the role of an expert on their own, and the Supreme Court has always resented that. It is the job of an expert. However, before relying on the expert's view, the court may examine its own accepted or proven facts and compare them with the contested ones. Thus, in Jogendra Prasad versus Joy Kanta Roy, the court decided that they must check expert premises in one case and appreciate the expert judgment in the other. When a direct evidence is well collaborated by circumstantial evidence and conforms to probabilities, there is no reason why it should not be accepted. The mere fact the expert opinion has a different conclusion than to a particular conclusion that has been brought in, it is not open to doubt. The data on which expert weigh must weigh by the court. Thank you for listening to my video. I would further like extend my gratitude towards my mentor, Mr. Jeevan Prakash sir, for giving me this amazing opportunity. If you have any further queries regarding the topic of this video, please comment down below and I will love to address them. If you find this video helpful, please give a like to this video. You may share it within your community and subscribe to this channel to view other such legal informative video from aspiring legal youth like us. Thank you.